Task 8 talks about operating as a representative in terms of the FAIS Act. Task 8 has 12 qualifying criteria. Let's look at Task 8, Qualifying Criteria 11. Explain the debarment process that should be followed in the event of a possible contravention of the FAIS Act. We are going to cover the debarment process that should be followed in the event of a possible contravention of and/or non-compliance with the FAIS Act. We will look at the following sections. Section 14 of the FAIS Act, which covers the debarment of a representative. Section 10 of the Board Notice 81 of 2013, which deals with the liaison between the FAIS Ombud and the Registrar or Commissioner. And Section 153 to 155 of the Financial Sector Regulations Act, FSR Act for short, which deals with the debarment by the Regulator, also known as the Authority, Registrar, Commissioner or FSCA. And Section 20 of the Code of Conduct, which deals with termination of agreement of business. You will see that we have already covered Section 14 in previous videos relating to the debarment process, but we are going to go through them again and build onto it specific additional information as it's related to the debarment by the Authority, Registrar or Commissioner rather than by the FSP and where that fits into the process. Firstly, let's look at Section 14 of the FAIS Act and hopefully you remember what we have previously covered. Section 14 of the FAIS Act covers the debarment of a representative. Here you can see and take note of the parties making up the FSP and their relationship with the client. The FSP must debar a representative or a key individual of the representative if they are satisfied that the representative A. no longer complies with fit and proper requirements, or B. contravened any of the provision of the FAIS Act. It is important to remember that the FSP can debar the key individual of the representative. We need to remember that the key individual oversees the representative and therefore would also need to take responsibility over the representative's actions. The reasons for the debarment must have occurred and become known to the FSP while the person was a representative of the FSP. The FSP must take action within 6 months of the representative leaving the FSP. A debarment that is undertaken in respect of a person that is no longer representative for the FSP must start no longer than 6 months from the date the person ceased or stopped to be a representative of the FSP. Let's examine the process of debarment. Let's take a look. The FSP must ensure that the debarment process followed is lawful, reasonable, and procedurally fair. Before the debarring process starts, the FSP must give adequate notice in writing to the representative, giving intention, reasons, and any terms attached or linked to debarment. If the FSP is unable to locate the representative in order to deliver the notification or notice letter after taking all reasonable steps, the delivery to the last known email or business or residential address, contact details on record, would be sufficient or enough. The FSP is to provide a copy of the FSP's written policies and procedures governing the debarment process. The FSP is to provide reasonable opportunity to the representative to make submission in response. The FSP must consider any responses and then take a decision. The FSP must consider any information regarding the conduct furnished by the FSCA, FAIS Ombud, or any other interested person. Once the FSP has made a decision, it must notify the representative in writing. Also notify the representative of their rights in terms of Chapter 15 of the FSR Act, to take the decision to the tribunal and any formal requirements in respect of the proceedings for the reconsideration by the tribunal. The FSP is to immediately withdraw the authority, contract, permission, or mandate that may exist for the representative to act on its behalf. The FSP is to remove the name of the person from its register of representatives. The FSP is to immediately take steps to ensure that the debarment does not prejudice the interest of the client, and any unconcluded business of the debarred person is to be properly attending to. An FSP must notify the authority within 5 days of debarment in a prescribed format. The authority can also be referred to as the FSCA, Registrar, or Commissioner. The FSP is to provide the authority with grounds and reasons within 15 days of debarment in a prescribed format. The authority requires the information for record-keeping purposes and to update its central register of all debarred persons. This register will be published on its website and other public media platforms. Debarment under this section is dealt with by the authority. The debarred person may not render financial services or act as a representative or key individual unless they have been reappointed under Section 13, Subsection 1, Paragraph B, Part 2, by providing evidence of reappointment requirements being met. Next, we will look at Section 10 of Board Notice 81 of 2003, which deals with the liaison between the FAIS Ombud and the Registrar. Take note that the Registrar may also be referred to as the Commissioner, the Authority, or the FSCA. We look at this to understand the flow of information and the relationship between these parties, which is important as this gives context as to why the registrar may take steps to debar a person. Here we will look at the relationship between the client, can also be referred to as the complainant, the FAIS Ombud, and the authority, also referred to as the registrar, commissioner, or the FSCA. The client lodges a complaint with the FAIS Ombud after exhausting all options with the FSP. The FAIS Ombud must report such facts or information arising from the complaint which may require the authority to consider taking action under the FAIS Act. This is where the authority may take action to disbar a representative. Taking into account confidentiality constraints applicable to the Registrar's Office, the FAIS Ombud is entitled to information or sight of documents that might be relevant in considering the complaint received by the Ombud. The Registrar and the FAIS Ombud must communicate regularly relating to mutual administration to avoid overlapping of functions. Next, we will look at sections 153 to 155 of the Financial Sector Regulations Act, which deals with the debarment by the regulator. So far, we have seen where the regulator fits into the process when they have taken a decision to debar a person. And we have seen the circumstances that may come to their attention to action a debarment. Now we will look at the process of the regulator. The following section covers the debarment of a representative by the authority rather than by the FSP. Don't let the terms confuse you, as the authority, registrar, commissioner, and the FSCA basically mean the same thing and refer to the same body. The authority for financial sector law may make a debarment order if a person has material contravention of the financial sector law, material contravention of undertaking in terms of Section 151, subsection 1, material contravention of the financial sector law with the use of someone else, conspire, aided, abated, etc. Material contravention of a foreign country law similar to the financial sector law. The process followed will be: before making a debarment order, the authority must send a draft order to the person and other financial sector regulators with reasons and relevant information about the proposed debarment. If the authority cannot locate the person to give them the notice, then delivery of the notice to the last known email or physical business or residential address based on contact details on the records of the FSP will be sufficient. The person must be given reasonable time to make submissions in response. Person must be given at least a month at a minimum to respond. In deciding whether or not to make a debarment order in respect of a natural person, the authority must at a minimum take into account any submission made by the person or on their behalf and any advice from other financial service regulators. Debarment orders takes effect from date it is served to the person or later date if or as the order specifies. When the FSP becomes aware of the debarment order against someone in its employment and or engagement with them, then the FSP must take all reasonable steps to ensure order is implemented or given effect. The debarment order prohibits a person for the period of debarment from providing or rendering financial services on financial products, generally or specified in the order, acting as a key individual of any financial institution, providing specified services to a financial institution. The debarred person may not engage in conduct that directly or indirectly contravenes the debarment order, cannot bypass this by using another person. The authority making the debarment may by order and or application by person reduce the period of the debarment, revoke the debarment order. Finally, let's look at Section 20 of the Code of Conduct, which deals with the termination of agreement of business. Here we have an illustration of the client and of the financial service provider and all its components as explained in the earlier video. An FSP will appoint representatives who act on their behalf to render financial services to clients. But as soon as the representative is debarred, resigns, etc. from the FSP and ceases or stops to act on behalf of the FSP, the FSP must hand over the work of that representative to another fit and proper representative within the FSP, so that rendering of the financial services to a client is not hampered and or disadvantaged. The FSP must allow the client to cancel a contract or agreement subject to the contractual obligation as outlined in the contract with immediate effect. If a client cancels an agreement based on the advice given by the FSP, then the FSP must make sure the client understands the implications of cancelling the contract or agreement. If the FSP is to cease or stop operations or rendering of the financial services, then this fact should be communicated to client and steps need to be taken to ensure that any business is completed or transferred to another FSP. If the representative or the FSP is debarred, ceases or stops to render financial services, then this fact should be communicated to the client and steps should be taken to ensure that any business is completed or transferred back to the FSP or another representative of the FSP. It is important to remember that the FSP must keep records of their interactions with their clients, and that the FSP cannot disclose any client's information without the client's written permission and consent. We have gone through all the sections relating to the debarment process that should be followed in the event of a possible contravention of the FAIS Act. Let's take a look at some questions to test your knowledge. Question 1. When may representatives still act as representatives once debarred? Choose the correct statement. 1. Only under supervision. 2. Under no circumstances at all. 3. Only when a FSP is present. We must choose from option A, B, C, or D. Pause the video if you need some time to think about the answer. The correct answer is option B. A representative may under no circumstances at all still act as a representative once debarred. Question 2. The FSP found out that James, a representative, falsified a qualification. What must be done? A. Let James work under supervision whilst the matter is being investigated. B. Suspend James. C. Debar James. D. Dismiss James. Pause the video if you need to think about the answer. The correct option is C. The FSP should debar James. The debarment of James is the most important, as this is the process to ensure that James stop acting as a representative for the FSP, as he no longer meets the requirements of fit and proper. Question 3. Joyce resigns with immediate effect from AMS Brokers. She got a job overseas in London. She is leaving on Friday after serving her notice. Before the notice period is over, AMS Brokers discovers that there was an undesirable transaction that took place. AMS Brokers require her to come for a hearing on the Monday after the notice period has lapsed. What should AMS do? A. They must debar her. B. They must wait for her to return from London. C. They can only debar her if she was present for the hearing. D. Continue with the hearing even in her absence. Pause the video here and think about the answer. The correct answer is D. AMS Broker must continue with the hearing even in her absence. Just remember that the FSP needs to follow the process before debarring a representative. And even if Joyce could not be at the meeting, she should or could provide a response to the notice outlining what happened, which will then be considered at the hearing when deciding on whether or not she should be debarred. Question 4. When a representative is debarred from the representative register, what would the purpose be? Choose the correct one. A. It would prevent a representative under certain circumstances from rendering financial services to clients. B. It would prevent an FSP under certain circumstances from rendering financial services to clients. C. It would prevent a compliance officer under certain circumstances from providing compliance services to clients. D. None of the above. Pause the video here and take a minute to think about the answer. The correct answer is option A. It would prevent a representative from rendering financial services to clients. Question 5. There are certain procedures to be considered with regards to debarment. Choose the correct statement. An FSP and/or key individual must A. Ensure internal processes and procedures exist. In other words, disciplinary procedures, etc., and are followed when representatives are debarred. B. Ensure that the debarment is kept confidential for fear of creating panic in the market. C. Ensure that debarment is excluded from the contract of employment or mandate. D. Ensure that reasons for the debarment, together with the FSCA prescribed debarment notification form, are sent to the registrar within 15 days before removal of name of the representative from the representative register. Pause the video here for a minute and think about the answer. The correct statements is option A. Options B, C, and D are incorrect. Question 6. There are certain steps an FSP has to take once he has debarred a representative. What are the steps to be taken? Choose the correct statement. A. Clients of the debarred representative are informed that no further financial services could be rendered to them. B. Clients of the debarred representative are not disadvantaged and that any unconcluded business is properly concluded or handed over to another representative of the FSP. C. All unconcluded business of the debarred representative is cancelled. D. All records of the debarred representative's clients are destroyed. Pause the video here and think about your answer. The correct answer is option B. The client must not be disadvantaged and that any unconcluded business is properly concluded or handed over to another representative of the FSP. So let's go through a final overview of what has been covered. Let's revise the process of debarment followed by the FSP as was discussed under Qualifying Criteria 9 of Task 8. We then looked at the relationship between the client, also referred to as the complainant, the FAIS Ombud, and the registrar, which brings circumstances to the registrar's attention, which may result in the registrar implementing the debarment process. We then looked at the circumstances and process of debarment followed by the registrar. Here we can see that the FSP will be notified of the debarment by the registrar and then will have certain duties and responsibilities within the process. So here we can see that the registrar notifies the FSP of the debarment, which would result in the FSP being required to immediately withdraw the agreement and/or contract that may exist for the person to act on behalf of the FSP. The registrar's process will continue after notifying the FSP as shown here. The FSP will need to follow the same process it would have followed after being notified of the debarment by the registrar, as it would have done as if it was the FSP that instituted the debarment as shown here. We then covered what the FSP needs to do in terms of its obligations, duty, or responsibility to the client of the debarred representative. We hope you enjoyed the video and learnt a lot. Please make sure to check out our other RE videos.